G'day everyone and welcome to topic 5 for Laws 11062 Contracts B. My name is Anthony Marinac and this week we're going to look at illegal contracts. Contracts which are illegal because they are prohibited by either the common law or by statute law. Now this is the last week in our examination of factors which can vitiate contracts, which can make contracts such that it's though they never were, that they have never had any validity whatsoever. Next week, of course, we talk about skills, and then after the skills week, we'll go on and have a look at the termination of contracts, breach of contracts, and remedies. So this week we wrap up vitiation, which will mean that to this point you will have studied the formation of contracts, the interpretation of contracts, and the vitiation of contracts. So we really are getting there. Let's get on with it. At the end of this topic, you should be able to demonstrate knowledge of the key reasons why contracts are forbidden. In this case, we'll start off with the common law. We'll talk about a range of contracts which are not forbidden by the common law, so they're not completely vitiated, but they might as well be because the common law won't enforce them. So you're not doing anything wrong by participating in these contracts necessarily, but don't expect the assistance of the court if something goes wrong. Third, we'll look at the ways in which statute law can enforce change the enforceability of contracts. And then finally we'll look briefly at the circumstances in which an innocent party who is a party to an unenforceable or an illegal contract might still be able to obtain some sort of relief. Let's start with illegal contracts, and we're going to start with the highwayman's case because it really does set out the idea here really quite brilliantly. Think about contracts as we've discussed them right the way since week 1 and formation. We talked about contract law theory way back then, and we started out with the idea of the classical contract theory, that people make a private law that is binding only upon themselves. And the idea of this private law is that it says, we will make a law, it will bind the two of us as parties, and if we do not obey our private law, then the innocent party can go off to the courts and seek relief. Now, what that means is that even though the law is a private law, the only reason that it can really work as a law is because the law of the land says so. You see, if the courts of the land, if the law of the land said, look, we've got no intention of allowing our courts to enforce these contracts, well then they wouldn't really be a private law, would they? Because they wouldn't be enforceable in the courts of the land. So society's got a stake. Even though contracts are a private matter between individuals, society's got a stake, and it hardly seems reasonable for parties to a contract to rely upon the courts of the land to enforce their contract if the nature of the contract is such that it's completely unlawful. Otherwise, you and I might make a contract which says that in return for paying me $5, you promise not to pay your income tax. Well, that doesn't work, does it? Let's try that again. In return for me paying you $5, you agree not to pay your income tax. And when the taxman comes to you and says, well, you've got to pay your income tax, you turn around and say, no, I don't, because here's a contract that says I don't have to. That doesn't work. It's kind of laughable. That's the idea behind saying that illegal contracts won't be enforced. Let's have a look at the highwayman's case. Now, the highwayman's case I can't give you an actual reference for because it occurred in 1725, and back then the recording of cases was still quite patchy and was quite often done by the newspapers as opposed to the law reporters. In this particular case, there is a newspaper report, but it's not in the form of a law report as we would understand it, but we do have reliable information that this case occurred. The case is called Everett and Williams. It was a chancery case that was filed in the Court of Equity Everett and Williams were highwaymen, so they were bushrangers in the United Kingdom. They had a partnership, and the partnership was that they would hold up coaches and travellers in the rural parts of England, in the forested parts of England. They would rob them at musket point, and then they would share the proceeds between them. And, you know, depending on honour among thieves and all that sort of stuff, that was a pretty reasonable place for them to start. And for a while it went along pretty well. They robbed and they plundered, but then eventually, poor old Everett, he started to feel that he was not getting his fair share of the loot. And so he decided that he should do something about it. And he thought about it and he thought, well, really, if you think about it, we've got a contract. Our contract is that we will rob people and we will sell their stuff to convert it into ready cash, and then we'll split the cash in half. He said, my mate here, Williams, he's breached our contract, so I'm going to sue him. Now, of course, he wasn't quite that blatant about it. He went to the courts of equity and he argued that the two of them had a partnership, and that the nature of the partnership, wait for it, the nature of the partnership was that they were dealers in second-hand goods. What he didn't say at that point was that the way they acquired those second-hand goods was by holding up carriages and robbing people at gunpoint. Now, of course, the Chancery Court saw through this and recognised that what was in fact going on here was that it was an illegal contract, because it was a contract to do illegal stuff. And so not only did the Chancery Court refuse to enforce the contract, but both of them were arrested immediately at the Chancery Court, and they were both later hanged. So, not, you would have to say, a particularly successful outcome for Everett the plaintiff. Now look, the highwayman's case is about as blatant a case as you're ever going to get, but these sorts of contracts which involve some form of illegal conduct, do still come up quite often, and they can be quite inadvertent given the complexity of the statutory world that we live in. It remains fundamental as a matter of common law that if there's a contract to commit an actual crime, so if you start with your criminal code and say these are our crimes, if there's a contract to commit anything under that, the contract is going to be void. The contract is not going to be enforceable. Now, on top of that, of course, the participants in that criminal action may face criminal sanctions, and on top of that, on top of the criminal sanctions, there's every possibility that the existence of some sort of contract or agreement may point the way to the extended liability of conspiracy, because we know what a conspiracy is. A conspiracy is a mutual or a joint criminal enterprise, and having agreements about conducting a criminal enterprise starts to look a lot like conspiracy. So not only will the courts not enforce an illegal contract, but the nature of an illegal contract may well result in much more significant consequences for the participants in that contract. The next type of contract which the common law will refuse to enforce are contracts which relate to sexual immorality. Now, until very recently, I would have argued, and I think most people would have argued, that this was a relic of the past. And the case which until recently everyone has used to discuss this particular rule is an 1866 case called Pierce and Brooks. Now, Pierce and Brooks was a case of, where a prostitute was able to hire a carriage, and she was to use the carriage in the pursuit of her business. I don't know exactly how the carriage was used, and I'll leave that to your imagination, but the person who leased the carriage to the prostitute knew that she was intending to use the carriage in the course of her business. And the the contract for the carriage was therefore regarded as void, because both of the parties knew that the entire purpose of the contract was to enable unlawful conduct. It was to enable sexually immoral conduct. Now, that of course was the 1860s, and a fair bit has happened since the 1860s in terms of sexual morality. Nowadays, conduct that we would consider not to be immoral at all is conduct which was absolutely outrageous in the 1860s. Premarital intercourse, for instance, is a very obvious one. Homosexual sexual activity is another very obvious one, which carries essentially no moral repugnancy in our modern day Australia, or at least not to the vast majority of the community now, whereas in times past there's obviously been a strong moral opprobrium attached to that conduct. So in a world where we now have quite great freedom of sexual immorality, it starts to make very little sense for the court to be looking over people's shoulders and saying, well, if you have a contract and it promotes sexual immorality, we're not going to allow that contract to be enforceable under the law. That starts to make very little sense. We all thought that this was dead in the water, that it was a relic of the past until 2012. Now, in 2012, a notorious case occurred, and the plaintiff was the lady who you see on the screen there in front of you, Madison Ashton. Now, Madison Ashton was a Sydney prostitute, and from what I understand still is a Sydney prostitute / escort of some notoriety, and was regarded as being among the most exclusive and high-priced escorts in the Sydney profession. She engaged in an ongoing relationship with a gentleman named Pratt, who was a billionaire. He made an arrangement with her which was contractual in nature, that he wanted her to leave the sex industry and he wanted her to be available to him sexually wherever and whenever he wished, and that in return for this he would set her up in an apartment, a great apartment, pay her an annual wage and establish a trust fund for her children. And she agreed. As a result, she left the sex industry, so she left the business that she'd been conducting, and by all accounts conducting quite lucratively. So she made quite a significant financial sacrifice on one hand. And she did so, of course, because on the other hand she was going to be receiving extraordinary financial benefits. Now, the interesting thing about this case is that this isn't like the movie Pretty Woman. This is not a situation where Mr. Pratt fell in love with a prostitute and tried to convince her to cease being involved in the sex trade. There was never any suggestion that Mr. Pratt wanted anything more from Ms. Ashton than sex. There was never any suggestion that he wanted her to be anything other than a mistress who was going to be sexually available to him. So there was no emotional content to the relationship at all. Mr. Pratt then died. And it turned out that he had not established the trust funds which he had promised to the children. And of course, he was not going to be able to continue to pay Ashton the wage which he had promised her. And so she sued. She sued and said, look, I want the financial benefits which were promised to me for leaving the sex trade. Now, the court considered it, and the court found that she was not going to obtain the relief which she sought. And the reason, one of the significant reasons that was put forward, was that The relationship was meretricious in nature. Meretricious means essentially based only upon finance, and it's a word that's really only used in connection with sexual relationships that are based on finance. And the court held that this meretricious relationship was sexually immoral, and that as a result the contract between them was unenforceable. Now, how do you feel? How do you feel about this decision? Because on the one hand, those of you who hold to what I might describe as strong moral views about sexuality might well think, well, she got what she deserves. I mean, this is a completely immoral relationship. This is a relationship that has no dignity in it, and so why should the family of Mr. Pratt have to give up some of their family resources to support this situation? On the other hand, though, if Mr. Pratt had made the same contract with his barber, if he'd turned around to his barber and said, I want you to stop cutting anyone else's hair and make yourself available to cut my hair whenever and wherever you wish at any time of day or night, and in return for that, I'm going to set you up in an apartment, I'm going to pay you a 6-digit salary, and I'm going to establish trust funds for your kids. Now, we might think that was a bit of an unwise contract, but there's no law against unwise contracts. We might think it sounds a bit ridiculous, but there'd be no suggestion that it was immoral. There'd be no suggestion that it was unenforceable. So why does it make any difference that the service that he was paying Ms. Ashton for was sex rather than haircuts? It's very difficult to make an argument on that basis unless you apply morality. And the problem with morality is that morality is contested. What might seem completely and utterly immoral to you might seem absolutely perfectly moral to another person. Morality also shifts over time. Earlier in this lecture we talked about homosexuality, which at one point in time, not so long ago at all, was thought to be highly, terribly immoral. Nowadays, if anyone was to stand up publicly and suggest that homosexuality was profoundly immoral, well then you might suggest that at the very least they would be well outside the normal or the majority public morality in Australia. Given that there are so many different people who have so many different moralities about sex, does it make any sense to say that contracts can be vitiated because they promote sexual immorality? My own view is that it doesn't. My own view, frankly, is that Ms. Ashton was hard done by, and that even though the contract which was made between her and Mr. Pratt was most unwise from his perspective, I don't see that there was any reason why it shouldn't have been enforceable. However, the reason, in the end, was that it still remains the case at common law that contracts to promote sexual immorality are not enforceable. The third topic we need to talk about is prejudice to justice. Now, there's 3 dot points here, but the first one's the one that really counts. You can't make a contract with someone which, as a result of which they don't go and tell police, or they don't give a statement. Now, of course, if someone is called to give evidence before a court, that's an entirely different kettle of fish, because they're going to get a summons, and not answering that summons is a contempt, and they'll be in prison. So we don't need to worry so much about that. Really, here we're talking about contracts which occur earlier on in the process. So let's say that you realise that somebody has been a witness to your criminal activity. You contact them and say, look, I know you think you saw some stuff, but I actually think you might have been having some memory problems since then, and I wonder if $5,000 might not make those memory problems a bit worse. And if the police happen to come around and ask you whether you saw anything, I wonder if this $5,000 would help you to realise that you didn't see anything and that that's what you should tell them. Now you can see that there's no summons been issued, there's no contempt of court, nothing like that. A person, a witness, is not obliged to answer the questions of police. They can tell police, go and get stuffed, I don't want to talk to you. A contract like that, if enforceable, would really knock over the justice process, wouldn't it? Because in order to get criminal convictions, we rely on the goodwill of community members to cooperate with police and ultimately to give their evidence in court. There's two other types of contract which are prejudicial to justice, and you don't see them very much anymore. We regard them as what they call antique torts, but they do occasionally come up from time to time. Maintenance is payment by one person of the legal fees of another where there's no interest. Now, maintenance does not refer to situations where there is an interest. So if you get a father paying his son or daughter's legal fees because he wants them to be able to maintain an action that the whole family believes in, well, that's no problem. That's not maintenance. Maintenance is where there's no legitimate interest in the case. Let's say that I become aware that somebody is suing a person that I hate, and I'd love to see that person's name be dragged through the mud, but I'm concerned that the party who's suing them might settle. And I contact them and I say, look, here's $10,000. Why don't you contribute that towards your legal fighting fund, but please make sure that this one goes to court. Now, the court's going to make that any contract to that effect unlawful because it's maintenance. Okay, it's not in the court's interest to have legal actions that are funded by people who are not parties before the court and who are not legitimately interested in the outcome. Finally, there's champerty. Now, champerty is where you essentially have someone who's using the courts as a form of investment. So they fund legal proceedings on the basis that they'll get a cut of the outcome. The champerty is also one of those antique torts. Doesn't come up very often. Does come up occasionally. I've given an example in the notes there, 2006 example, Campbell's Cash and Carry and Fostiff. That's reported in volume 229 of the Commonwealth Law Reports at page 386. And what happened there was that there was an agent who was used to try and put together parties for a class action, and the agent had no interest in the action other than to try and encourage people to participate in it. But if they could encourage enough people to participate in it, then they would be paid out of the proceeds of the action. That was champertus. For a while, there was a little bit of a controversy about whether no win, no fee lawyering was champertus, but now it's pretty clear from all of the law societies and law councils that no win, no fee lawyering is acceptable and is not champertus. Next type of contract which the law regards illegal, contracts which promote corruption in public life. And the classic case that everyone refers to has nothing to do with the late Sir Joh Bjelke-Petersen, but it does have something to do with knighthood. And the case is called Parkinson and the College of Ambulances, which is a 1925 case and was reported in the second volume for that year of the King's Bench at page 1. Now, Parkinson, he made a donation to the College of Ambulance on the understanding that he would get a knighthood in return. Paid all his money, waited for the announcement, the Queen's birthday honours list to come out. Honours list came out, no mention of our mate Parkinson. And so what do you think he did? He turned around and said, well, hang on, I paid my money, where's my knighthood? This is a breach. This is appalling. I was promised a knighthood. Where is my knighthood? And he sued. The Court of King's Bench says, no, it doesn't work like that. You cannot buy a public position, whether it's Member of Parliament or knight. These positions are not to be traded. They're not to be contracted. Now, by the same token, if I wanted to get an approval for a major public investment, I shouldn't be able to walk into the office of, say, the Premier and leave cash in a brown paper bag and then say, well, we've got a contract now. I'm going to accidentally leave some money behind here and you're going to accidentally make sure that I get the approval that I need. Now, that's not going to work, is it? That's not going to cut it. So, any of those contracts which promote corruption in public life, not only may they fall afoul of laws relating to corruption in public office, but they're also going to be unenforceable simply because they tend to promote corruption. Now, we're going to move on now because those are the contracts which are unlawful. The contracts are unlawful in themselves. The next group we're going to look at are contracts which are void. So you're not forbidden to enter into these contracts, but the court's essentially saying, if you do, on your own head be it, because the court is unlikely to allow either party to sue on the basis of the contract. So the contract is void as far as the law is concerned. The first type of void contract is a contract which ousts the jurisdiction of the courts. So what these contracts do is the contracts purport to bind the parties not to sue. Now, of course, that's quite prejudicial to our system of justice because at the end of the day, any party who has a legitimate claim ought to be able to bring that claim before the courts. It's also not reasonable to say, well, we're going to have a contract, and the purpose of the contract is to enable the courts to enforce it, but at the same time we're going to make an agreement that the courts won't enforce it because neither of us are allowed to go to the courts. The whole thing's silly and makes no sense. Having said that, remember last term when we talked about the intention to create legal relations, we talked about honour clauses. And an honour clause in a commercial agreement says we have no intention to create legal relations. Now, honour clauses are perfectly valid, even though they have the effect of ousting the jurisdiction of the court. Because what an honour clause says is, you know what, this isn't actually a contract. And the reason it's not a contract is because we've both agreed that neither of us will be allowed to go and seek the court's relief. The third thing to think about is a lot of contracts these days will include some form of words that says that the parties are required to go to alternative dispute resolution, or they're required to follow some sort of dispute resolution process before they can commence any legal action. Those sorts of clauses are also absolutely valid because even though they say effectively you can't go straight to the court, you can't go to court first, they don't prevent any party from going to the court. It still remains something which a party can do at the end of the day. Second type of void contract is contracts prejudicial to the status of marriage. Now, it's been a long time since any of these came up in the courts effectively. In all likelihood, this really is an antique rule and is one that probably won't be upheld if it comes back before the courts again, but we won't know for sure until that actually happens. A number of types of contract in the past have been held to be prejudicial to the status of marriage. One was a contract not to live together after marriage. Now, you can see how even in the modern world that might potentially be seen as unenforceable if, for instance, a marriage was arranged in order to secure somebody's immigration status, and as part of the marriage deal there was a contract where the Australian citizen who's marrying a foreign national obtained a certain sum of money, and the foreign national agreed that there was no need for them to live together as though they were actually married. Well, you know, that comes pretty close, you'd think, to being void for being prejudicial to the status of marriage. A contract by a married party to marry another party is apparently a void contract. Now, I don't know whether that would fly in the modern world. If somebody, for instance, was married but separated and made a deal that they were going to marry somebody else, provided that they had secured their decree absolute of divorce before they actually tried to marry, that is, provided they didn't commit the offence of bigamy, then one can really not see where the problem could be. And of course, if they did commit the offence of bigamy, well, then the contract would be an illegal contract, as we referred to earlier in this lecture. So there'd be no need to have the contract void because it prejudices the status of marriage. It could just be void because it's unlawful. The third type I've listed there is contracts by an unmarried party not to marry at all. Now, for the life of me, I can't see why this is any of society's business, why a single person ought not to be able to make a contract not to marry at all. But old school common law takes it as a basic principle that it's best for society if everyone grows up and gets married and has kids. And so a contract by an unmarried party not to marry at all is, according to the old school common law, likely to be void for prejudicing the status of marriage. Finally, and perhaps most curiously of all, marriage brokering. A contract with a marriage broker is void. So someone who arranges marriages has to do this without the protection of contract law. Now, given that within certain ethnic communities, certain people are responsible for brokering marriages, and that this is done quite often with the absolute consent of the people who are going to be married, I don't see the problem. I don't see why our society would have an interest. For instance, I'm aware that in some Mormon communities practice placement marriage. Now, placement marriage, according to the teachings of these communities, occurs where where God reveals to a woman the identity of the person who she's supposed to marry, and she goes to the elders of the community and says that she's had this revelation, and the elders then pray on it and come back to her and say, yes, we agree. Now, as that process is brokered, because they're not dealing with a situation where there's a romance between the parties and they make a separate and independent decision as a couple to get married, there is a form of brokering going on there. But provided both parties to the marriage freely consent to the marriage at the end of the day and they're not manipulated into it, it's very difficult to see what sort of harm the broker does. Looking at it even further, we've got, particularly on the internet now, a massive, massive introductions industry. And some of that introductions industry is very focused on finding people who want to get married to other people. It's difficult to see why contracts with those sorts of introduction agencies ought to be considered in any way immoral, improper or unenforceable. So one day I suspect we'll wake up and find that the common law has changed and contracts prejudicial to the status of marriage are no longer void. But as it stands, what the common law says is these are void. Next we'll talk about restraint of trade. Now this one is not antique. This one is very much alive and very much important to commercial reality. Contracts which restrain trade are not automatically void. And there's not necessarily anything improper about them at all. In fact, they may well be completely commercially necessary. So that means we have to work out how to tell the difference. For instance, it's okay if a business buyer makes a contract with the business seller that says, look, you're selling us this business, you're selling us this butcher's shop. We want you to agree as part of this deal that you're not going to go next door and open up another butcher's shop. The reasons for that are pretty obvious, because part of what's being sold is the goodwill and the regular custom of the people who come to the butcher's shop. If the old butcher opens up again next door, well, many of those customers are just going to follow the butcher next door. They're not going to go to their old butchery, are they? and so much of the value of the sale would be removed. Similarly, it's pretty reasonable for somebody to say to an employee, I want you to make an agreement that if you leave this employment, you're not going to set up next door and start challenging our business. You're not going to take half of our clients with you. On the other hand, restraint of trade could go too far over the top. And so a court will look at a number of factors, such as the extent of the activities that are restrained under the restraint of trade clause, and also the physical distance of the restraint of trade. Restraining someone from leaving, restraining a business seller from opening up a similar business in the same shopping centre, well, that's almost certainly going to be okay. In the same suburb? Maybe. Restraining them from operating another business anywhere in the whole city? That's starting to go a bit over the top. The whole state? Certainly not. The whole country? Forget it. What the court does is asks two questions. First, is the restraint on trade fair as between the parties? And so they'll look at these factors like what is being restrained and what the distance is. So is it fair just between the parties? And then second, they'll bring in the public interest. Is the restraint on trade in the interests of the public? So, for instance, if the restraint on trade has the effect of removing necessary competition and therefore driving up prices for whatever the goods and services are, that's not in the public interest, so it's probably not going to be enforceable. So there's two questions there. Remember this is the way it needs to be set out in examinations and so on. First, is the restraint on trade fair between the parties? Second, is the restraint on trade in the interests of the public? So there is a public interest here, even though the contract is between two private parties. So that's all of the common law stuff dealt with. Now we've got to look at contracts which are prohibited by statute. Now, we've already said that contracts for something illegal are void, but of course there's a whole world of statute out there that doesn't create crimes, but still restrains people in their activities, still allows or prohibits particular activities. So how do those sorts of statutes affect contract? Well, first up, if a statute expressly prohibits something, even without creating an offence or a criminal offence, if a statute expressly prohibits something, it says a person must not, then a contract to do that thing will be void. So you cannot make an agreement to get out of some rule that's imposed by the general law. More interestingly, there's this thing called implied statutory prohibition. So if the statute prohibits some form of behaviour which comes within the contract, then the contract will be void. So, for instance, let's have a look at the case of Pham and Diane. Now, this is a 2005 case reported in volume 63 of the New South Wales Law Reports, and it revolved around a pharmacist. He had a business contract with his brother-in-law who wasn't a pharmacist. Now what the law says is, if you're not a pharmacist, you can't participate in the pharmacy industry. Okay, you can't do it. As a result, the pharmacy agreement was illegal. So you can see that's a pretty clear example of a specific prohibition that's created by the statute. And they've ignored that prohibition and therefore the contract is void. Now something implied is a little bit more subtle. What if, instead of banning something outright, instead of saying a person must not, what if the statute merely imposes a penalty? A person who does X or Y thing, if they do so, will be liable to pay a fine of $500. Well, that means the court's in an interesting position, isn't it? Because on the one hand, if the contract requires somebody to go and do that thing, well, the court could quite legitimately turn around and say, well, no, it's a contract requiring you to ignore that prohibition, and therefore we're not going to enforce it. The contract's going to be void. And yet, on the other hand, why not just enforce the contract and require the person to pay the fine? I mean, that's what the statute seems to want them to do. So, in fact, the court has the option of both. The court may choose to make the contract void, and it may choose to enforce the contract and make the guilty party pay the statutory penalty. The long and the short of it, though, is that you're much better off to make sure that your contract is not prohibited by statute. Now, there are some circumstances under which, even if you've got an illegal or a void contract, someone is still going to be able to obtain some level of remedy. The rules for this were identified in a case called Nelson and Nelson. This is a 1995 case reported in volume 184 of the Commonwealth Law Reports at page 538. Now, a party who's involved in an illegal contract might still be able to obtain some sort of remedy if there's a bunch of circumstances that they can demonstrate. The first is that they have to have been either ignorant or mistaken about whatever it was that made the contract illegal. That makes sense. If you didn't know that the contract was illegal, then you can always argue that you would never have agreed to enter into the contract if you knew that it was. Second, if the contract is for the benefit, if the statutory scheme was for the benefit of the class that the claimant is a party of, well, then they're likely to be able to claim relief. What on earth does that mean? Well, what that means is that in the case of our law about pharmacists from Pham and Diane, that's meant to provide protection for consumers. So if the person who had the contract, let's say they had a contract to purchase certain medications from the pharmacy, well, the law's there to protect them. So given that the law's there to protect them, it doesn't make any sense to remove from them the protection of contract law simply because the pharmacist in this case is conducting himself unlawfully. So under those circumstances, they may still be able to claim. Third is where the contract was induced by the other party's fraud, oppression or undue influence. In that case, it may well be that the courts may apply some sort of equitable remedy to bring the claimant back to a position where they're not suffering unduly as a result of the unconscionable or improper conduct of the other party. And finally, if a contract is a contract which will involve the conduct or involve illegal conduct, but that conduct hasn't actually occurred yet, then it may well be that the breach, like if the breach has occurred before the contract has required any unlawful activity, well, nothing's actually been done yet that's been unlawful. So there may well be no reason why the courts can't go ahead and enforce. So under some very limited circumstances, an innocent party who doesn't know that what they're doing is unlawful, or who's entitled to the protection of the statute, or who hasn't actually carried out the unlawful activity, or who's been the victim of fraud, oppression or undue influence, they may still be able to seek the relief of the court. So what have we looked at this week? Well, we've looked at the fact that contracts to commit a criminal offence, a tort or a fraud are all forbidden by common law. The contracts promoting sexual immorality are forbidden, although I can't for the life of me understand why. Contracts which prejudice the administration of justice or which promote corruption are forbidden. Contracts ousting the jurisdiction of the court are void. Contracts prejudicial to the status of marriage are void, although heaven alone knows what that means in the modern world. Contracts for restraint of trade are the most interesting ones because they're permissible but only if the contract is both fair as between the parties and also in the interests of the community. And finally, contracts are void if they require conduct which breaches either an express or an implied prohibition contained in a statute. Guess what? That means we're done. We're done with vitiation of contracts. Next week, we're going to talk about skills. We're going to talk about unlocking the code of citations. And then after that, we'll get on with the second half of the course and we'll knock over the whole question of breach and remedy. Have a great week, everyone. I'm looking forward to talking to you through the week and during the tute, and we'll look forward to the next lecture next week.